We're certainly seeing some new issues arising from the Envoy decision, which was an Ontario Superior Court decision involving Envoy and the Government of Canada. That's a decision that dealt with a situation involving an incumbent bidder in a procurement process and a very significant Government of Canada project that went out to bid. Prior to the decision in Envoy, there really hadn't been many cases dealing with procurement situations involving incumbent bidders and any duties that are in play with respect to that type of procurement. The Envoy decision does shed some light on the obligations that procurement authorities do owe to bidders, be they incumbent bidders and new bidders in a procurement process. In the Envoy procurement process, the incumbent bidder was successful. However, an unsuccessful bidder challenged the award to the incumbent, and what followed was a lengthy hearing before the Ontario Superior Court that ran over 15 months and led to a judgment of over 300 pages in length. There were very many interesting points that came out of the judgment that those in the procurement industry will need to be mindful of going forward. One of the focal points of the decision in Envoy was the recognition of the duty of fairness in the bid process. And it is recognized that when dealing with incumbents in a bidding process, incumbents will clearly have knowledge of the project going forward that other bidders will not have. And it was the balance of dealing with that particular knowledge and dealing with the other bidders fairly that really came into play in this decision. In Envoy, the incumbent bidder had particular knowledge of the work that was to be done in the project. The incumbent was able to use its past history and the past knowledge that it had gained on the project and use that information in submitting a lower bid than other bidders for the project going forward. In the end, the court found that the manner in which the procurement was set up did favor the incumbent to the disadvantage of the other bidders. The court found that this was in effect a breach of the duty of fairness owed to all bidders in the procurement process. We can certainly expect that there will be more scrutiny on procurement authorities involved in procurement exercises involving incumbent bidders. The question of the duty of fairness will be coming to the fore on all procurements involving incumbent bidders, and challenges to awards involving incumbent bidders can be expected. Those involved in the procurement process going forward should be very mindful that when dealing with potential incumbent situations, they should establish procurement procedures that are fair to all bidders and take into account the fact that the incumbent may have knowledge that the other bidders don't have. With that being the case, the procurement process needs to be set up such that the incumbent cannot take advantage of any past knowledge or past history that it has gained through any activities with the particular project.